Greetings, everyone. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Oops, wrong one. Oh, we're going to flash again tonight. Okay. Well, let's do it this way. Okay, we can read it from here. And as we get started, I want to thank everybody for your support, of course. Please hit the like, share, and subscribe button. And of course, there's PayPal links in the details section for anybody that wants to share some love. And welcome, Russ. Welcome.
Greetings, brother. Good to see you. You look a little better this evening.
Yeah, I'm feeling better. I'm feeling better.
Good, good, good.
All right. And as we get started tonight, where we left off was the Olmsted, Mitchell and E. Olmsted Supreme Court has original jurisdiction in the case. The next part of it, there's a case text on it. A party is bound to choose between two inconsistent or alternative rights or claims. In cases where there is a clear intention of the person from whom he derives one, that he should not enjoy both. Story EQ at section 1075. In cases of implied election, the foundation is the intention of the author of the instrument. Foundation of intention is that of the author of the instrument. So the author of the instrument is the people that provide the instrument. It's an offer and acceptance. So they're the ones that authored it to begin with, and then another party has to accept it, which extending to the whole disposition is frustrated by the failure of any part, particularly and specifically the very beginning. Section 1077, Crosby versus Murray. It says, and in cases where the will was not well executed in the place of the forum, the heir has taken a benefit under the will as well as inherited as heir. If the will was not made according to all requirements of law, it could not be read. It must be a perfect will in the forum. And this is again, that's that perfection of everything. It's not well executed. It was entered into heir as a probated estate when there is, in fact, a living being growing up and was going to take upon a certain capacity, but it's what is it? Equity does not complete an imperfect gift. It's imperfect. It's an imperfect gift until it's perfected. So, in, on, and for the record, the failure of any part is frustrated by the failure of any part. Not well executed in the place of the forum. The heir has taken a benefit of the will. If the will was not made according to all requirements of law, it could not be read. It must be a perfect will in the forum. And I, Keith, do not believe there is a way to perfect a legal name. That's just my belief and opinion, though. What do you
I
think?
don't, I don't see how that could be true either because we didn't give ourselves these names.
Exactly. So the only
So,
will we carry is not in the name, but in our Father, which art in heaven. Hallowed be thy name. Shh, it's secret.
right.
You're not supposed to expose that beneficiary, the living soul. That would impede his benefit. Okay, so let's take a look at this. I got to switch. To Sella versus David. April 24th, 1931. June 27th, 1931. Equity, jurisdiction, corporations, officers, elections, mandamus, acts of 1836 and 1907, preliminary proceedings. Equity has no power to remove officers of a private corporation. So, first and foremost, you can't go in there contesting their title or their office. If you want equity, you must first come with equity. If you want peace, you must first come with peace. You cannot come in making threats that you're going to remove them from office. You let them know it's a matter of equity, and you're coming in with equal station of privacy, period. The proper remedy to compel the holding of an election for officers of a corporation is by mandamus, man to man, mano y mano. Bring forth the body. This is why you have a right to see your to question your accuser. You have the right to be self-determinant. You have the right to ask your own questions. You have the right to seek your own counsel. Where the determination of validity of a corporation election is but incidental to a substantive complaint of which equity has jurisdiction, it may have power to pass upon the validity of the election. So no matter how valid you want to make the election, I'm not contesting that. I'm contesting that there's a jurisdiction of equity that has power to pass upon the validity of the election and overcome that. It's a matter of correction and reconciliation. A court of equity cannot acquire and retain jurisdiction of matters not justiciable before it. Equity is a matter of privacy, such as the removal of corporate officers or the direction of corporate election through the medium of another matter pleaded within its cognizance. This is like a third person intervenance because it's in personal matter. That's always going to be the subject matter in these commercial forums. Admiralty Maritime. It's going to be relating to the military person in contract. Federal employees or contractors. Pleaded within its cognizance. This is what I mentioned a few times in relation to recognizance, recognized. You provide an ID so that they can recognize, recognizance. But as to which after hearing it does not act and grants no relief. Through the medium of another matter pleaded within its cognizance, but as to which after hearing it does not act and grants no relief. That sounds a lot like the plastic straws and paper wraps. It was legislated, and after hearing it, didn't really have any relief because then they just started using paper straws and plastic wraps. Kind of stupid. The principle of equity having jurisdiction as to part of a controversy will round it out and afford full relief. So instead of just replacing the plastic straws, they come with the relief of all the plastic or use of plastics. does not apply to where the court does not act upon the matter which gave it dominion over the case. These are administrative courts. They only administrate that which is legislated, but only on the incidental subjects over which in themselves it was without power. Equity having jurisdiction as a part of a controversy does not act upon the matter which gave it dominion over case, but only on the incidental subjects, the people, the actual things, the verbal things, the ones that are self-determinate. That's the principle, being self-determined as to whether you want to be subject to somebody else's power, over which in themselves is without power. Where does that power come from? Our Father which art in heaven, hallowed be thy name. Again, that's Isaiah 43:1. Real quick, I want to remind everybody, hit that like, share, and subscribe button. And I appreciate everybody's support. What's on your mind, Russ? Does that bring anything about?
Yeah, well, it all makes kind of perfect sense to me. Um, when you started this off, those citations, any of those, that's all consenting to all.
Yeah, those are negotiable instruments. All you have to do is learn how to negotiate them. When you learn what equity is, you bring it straight into privacy first and foremost. Even contracts maintain privity just as much as trust maintains privity. Trust is what actually makes the law, and the contract is the law of the trust. So you make everything private. You do that by declaring it private first and foremost. Sorry, I'm not a public officer. I'm not a defendant nor a plaintiff. I'm not involved in those commercial courts. That's why they demand that ID all the time. That's that address being used as a legal name in that grammar style. That's the presumption.
Yep.
So let's continue on. It says where a court of equity has jurisdiction under one phase of controversy pleaded, but until relief is not meted out as to such phase, the lack of jurisdiction is not manifest. The Act of June 7th, 1907, Public Law 440, which relates to preliminary proceedings as to jurisdiction, does not apply. So in equity, there is no preliminary proceedings. You just take it into equity right away. That's the determination that you're proceeding in privacy. It's not a matter of public preliminary proceedings that are held in those administrative courts. Jurisdiction in equity does not apply under the Act of June 6, 1836, Public Law 74.8 or 784, where there is an adequate remedy at law. Not in law, but at law. This is the legal system. So if the legal system can provide an equitable remedy, then you do so. That equitable remedy in this legal system is merely the correction of the record so that all of the remainder is reverted back to the intended heir and legacy in a merger after a resurrection or reconciliation of that record in a new name. And of course, constructed as a trust and expressed as so, judicially. Where a remedy is provided at law, it must be strictly pursued. Argued April 24th, 1931. So if there's no remedy at law, which all legal is just equitable, if you're willing to provide a contractual setup wherein that credit can be reverted through that remainder, then that's what you do. Take everything that's been established as assets throughout your life through a correction of a record, transfer of the titles, all the way up to the Postal Service. Those titles are resurrected in the new name. Again, that's all your education, medical, employment, tax records, everything. Your licenses, identifications. No, you're a living soul, and every breath is an act of God. As far as I know, God is no respecter of persons, and persons operate in commerce. You have to learn the separation between yourself and the person. You're not the person. The person is everything written down in those papers and expressed um, vocally throughout generations. It's the legacy. It's the story of our own actions. Our actions are separate from the story. They're just translations or transliterations of what other people have seen or heard about us. So the next thing I want to go to reference to Sawyer 124 U.S. 200 1888 in the U.S. Supreme Court. A court of equity has no jurisdiction of a bill to stay criminal proceedings. Again, if you want equity, you got to bring equity. But if you bring equity and they refuse to move to equity and continue on with proceeding against you, again, in these administrative courts, they're operating under probated estates. They have no jurisdiction over the estate of a person or over the estate of a person who is in fact alive. So, as a living soul, and they're using your name in front of them, they're administrating a probated estate. And all you have to do is very simply and knowledgeably, wisely profess your express trust in the living will of his will. How, our Father, which art in heaven, hallowed be thy name. So let's screw all these name things and let's talk about the will. That's what they're looking for, is the living will. And you can orally express that before anybody. It's really simple. I don't really have a will of my own. It's a spiritual will of every man that wants to do unto others as they would rather have them do unto you. Oh, no man anything but to love one another, for to love one another is to fulfill the law. And I believe that discernibly to be the will of our source of life, and that is the heavens and our Mother Earth. I don't know how any other way to express it, but that's the best I can do. A court of equity has no jurisdiction of a bill to restrain the removal of a public officer. So you can't use a court of equity to remove a public officer by accusation of his oath or his title or his office. So if you go in there and do that, you're screwing up your own equity. If you want equity, you must come with equity. If you want peace, you must come with peace. If you want resolve, you must come with the resolve. In other words, you have to be able to solve it yourself. Ain't no one else going to do that for you. It works pretty good for them. Circuit Court of the United States has no jurisdiction or authority to entertain a bill in equity to restrain the mayor and committee of a city. It doesn't talk about the county, doesn't talk about the state, doesn't talk about the federal government. It talks about the mayor and the committee of a city. That's the mayoral form of government. Again, the major form of government. They issue the private municipal bonds using your information as a quote resident. Quit it. In Nebraska.
So that's basically saying that the judge can't even entertain any of that?
Oh, but again, you have to be able to bring all this knowledge to him to shut him down at every attempt.
Correct, correct. And I feel I've been pretty successful even without this information thus far, but I'm far behind you guys on a lot of this stuff. But it already resonates in your mind, my mind anyway, that it makes perfect sense. I don't
Well, yeah,
understand why more people are not
once you
catching on to
follow
this.
Yeah, once you follow the money, everything's pretty much generally started with municipal bonds. And then you've got your corporations start out with federal bonds. You know, they're the ones that do the big investments. And they're investing in the municipal bonds because they're using your information as a resident as the investor.
Right.
That's why you're paying all those bills. You're not supposed to be the investor, you're supposed to be the creditor. You're supposed to lend unto the nation. My people are destroyed for lack of knowledge. The information is the knowledge, and the knowledge is correction of the record that you're the benefactor. You're the one putting all the facts on the record. Now it's come time, high time that you repent for your errors, correct them. That's all it is. Everybody's so afraid of criticism, and they won't realize that the very best interest for themselves is to learn how to criticize themselves so they can bring their own corrections. To live simply and just say, hey, listen, I'm doing things according to the law. That's the simplest law there is. All these other jurisdictions, numerous, and they're growing day by day. Over time, the jurisdictions have grown enumeratedly. Everybody keeps creating new ones. Now we've got a transgender jurisdiction. Did you know that? We have an African American jurisdiction. Did you know African American is trademarked? Think about this
Yeah.
stuff, folks.
Yeah. Yeah.
So in Nebraska, from removing a city officer upon charges filed against him for malfeasance in office and an injunction issued upon such a bill, as well as an order committing the defendants for contempt in disregarding the injunction, is absolutely void, and they are entitled to be discharged on habeas corpus. The writ of mandamus. This was a petition for a writ of habeas corpus in behalf of the mayor. The writ of mandamus, I believe, is a writ of error of some sort, saying they've got the wrong person. Bring forth the body to be identified, and this is the release of the body. This was a petition for a writ of habeas corpus in behalf of the mayor and 11 members of the city council of the city of Lincoln in the state of Nebraska, detained and imprisoned in the jail at Omaha in that state by the Marshal of the United States for the District of Nebraska under an order of attachment for contempt. See, it was the government that went after another governmental body for contempt. This contempt charge is never supposed to be used against the people. Okay? Comprehend that. Made by the Circuit Court of the United States for that district under the following circumstances. This contempt charge is set out in the concept that you're following a certain set of rules that have been laid out before you, and that you're part of that associative set of rules that everybody else is following concerning the city council, the city of Lincoln, and the mayor. That's where they get you, that resident. You're supposed to be in contempt because you already placed in on for the record the legal use of the legal name as a legal fiction, as a presumption of the facts put before the court, that haven't been rebutted properly. It's all we got to do is rebut those. Knowing those elements and why they're there and how they operate helps so much. No tongue shall prosper against you. You shall rise up and condemn anybody that places judgment. You're supposed to know those tongues, so learn them. On September 24th, 1887, Albert L. Parsons presented to the circuit judge a bill in equity against said mayor and councilman, the whole of which, except the title, the address, and the signature, was as follows. Your petitioner is, and for more than 15 years last past, has been a citizen of the United States. Oops. And a resident of the citizen of the state of Nebraska. Oops. And as such citizen has been and is entitled to the equal protection of the laws and to life, liberty, and property, nor could he be deprived thereof without due process of law, nor denied the same within the jurisdiction of the United States or of the state of Nebraska. On the such and such day of April 1886, this complainant was duly and legally elected to the office of police judge of the city of Lincoln in Lancaster County, Nebraska, as soon thereafter did duly qualify and enter into the discharge of his duties as such police judge, a military capacity, You cannot bring equity in a military capacity. That's why they denied it. See, you have to come with equity. That means you have to come under the full armor of God, which is in all your manual nakedness with your full spiritual affront. Man to man, living soul to living soul. When you're under an obligation as a police judge, you've got to do it's like taking a plural oath. And ever since, and yet at this time, complainant has held and exercised all the functions performed all the duties of the said office. Office, again, being the offerer. He was making offers. He was tempting people. It's called temptation, living in duality. And for the last 6 months and more, all of the respondents except the said Andrew J. Sawyer have been and yet are duly elected. So he was recognized as of the same class. And like I said, if he wants to bring equity, he can't do it against his fellow man contesting their office and their duties. It's called descent among the ranks. And again, this is a military ranking system. It's called dishonor. You're not supposed to bring dissent among the ranks. You're supposed to do the shit in private. If you want equity, you must bring equity. If you want privacy, you must bring privacy. But if you do this shit in public against your fellow man, they're considered of the same office, and you're not supposed to be doing that. That's in violation of Matthew 18, verses 15 through 20. You have aught with your brother, you're supposed to go to him in private first. If you have aught, AUGHT, if you have weight, if you have a difference in weight with your brother, you have aught with your brother, you're supposed to go to him private. You're supposed to square up in private. I hope you learn how to get around to it. Qualified and acting councilman of said city, and the said Sawyer has been and yet is duly selected. Went by the last name, military. Okay. And qualified and acting mayor of the said city on the such and such day, 1887. For a long time prior thereto, there was a certain ordinance in the said city, full force, relating to the removal from office of any official of the said city. So he's trying to use it as city ordinance when he clearly knows that equity is a superior jurisdiction, and he's trying to use equity in the jurisdiction of the municipality. Can't do that. You can't mix jurisdictions, folks. This is what happens when they indoctrinate you into doing all this paperwork and everything. All those applications, registrations, employment apps, opening bank accounts, filing taxes, going to the doctor. Going to the doctor is creating a securities instrument. That securities instrument that it creates when you turn around and get prescriptions. They, again, also, just like the courts, the clerk of court down there, they have a medical treasury, a medical treasurer that converts somewhere in the system, whether knowingly or unknowingly, intentionally or unintentionally. I don't know. I don't give a rat's ass. I have evidence that it's done. And that's that they convert the last name to a firm name. And I'm sure, just like the administrative courts, they also convert the social security number to an obligor number. I mean, it seems to be that the law is uniform throughout the jurisdictions. Therefore, I would assume that the investment process would be uniform throughout the jurisdictions as well. So if they want your data elements and they want to invest in them, they've got to do some converting in order to do that investment. Credit default swaps. The next one I've got is a reference to HJR 192 again, talking about how it's the Federal Reserve notes have zero intrinsic value. And then I've got another reminder of 20 CFR 422.103 Social Security numbers, wherein that's the individual's name and number, identify the record. 20 CFR 422.104 says who can be assigned a social security number. And that's where you're going to find the definition of a person under the definition of you.
Share your screen.
There, well, I'm not sharing it. I'm just reading it.
Oh,
Otherwise, I'm just clicking back and forth or fast forward to these different sites. I'm just reiterating things that we've already gone over. You means an individual who owes a debt to the United States within the scope of this subpart, 20 CFR 422.402. And then I've got a note here. I did contact the Iowa Vital Statistics as it relates to the original certificate of birth prior to adoption. And she gave me some information to get a hold of the registrar at the local county where I was born. So I've got that on my list of to-dos. I've got a note here for 39 USC 2603. And again, if you guys are familiar with 39 USC, that is the Postal Service. And like I've said before, we're talking about international venue, we're talking about International Bank of Settlements, and we're talking about the judicial office being that of, come on, there we go, being the post office. Judicial Office Department is a neutral and independent office, or excuse me, forum within the United States Postal Service, who is the registered agent under the the Postal Regulatory Commission, who allows the local municipal committee the attachment of a street name with a securitized bonding number under the Postal Realty Trust, which is a real estate investment trust. They are the true investor, and they are using a resident by credit default swaps as the investors. In my opinion, of course. Settlement of claims for damages caused by the Postal Service. And it is all these organizations that are actually required to use the Postal Service for mails that are entered into the mails, letter posts that are entered into the mails. And as I've distinguished before, a manifold dispatch article is something that passes through the mail under freedom of transit, which is guaranteed throughout the entire territory of the Union and is expressed by franking rights of making prepaid postage impressions connecting the credit source. And I know it sounds so simple, but it's much more complicated than that. And I urge people again, don't believe me, don't believe your neighbor, don't believe the government, and don't believe your mother, for crying out loud. Do your research so you know. That's why I'm going over all of this. And again, like I said, this is just a brief. What I have extensively above and beyond this is so much more. But again, like I said, I'll be able to refer to most of it any step along the way, discussing with anybody. And again, I urge anybody that finds anything wrong with what I'm saying, please hop on panel and help express it to me. When the Postal Service finds a claim for damage to persons or property, and property is moved via persons in commerce. Otherwise, a living soul can move his own property however they define it themselves. My mom and dad called a 1974 Nova New Blue because their old car, which they called Old Gray, was an old gray Chevy Impala. So they gave them names. They literally named their property. Just like Adam named all the animals. Adam named his wife. The name is important, but it must be proper to be able to dismiss it pro per. It is not cognizable under section 2672 of Title 28. It may adjust and settle the claim. 28 U.S. Code 2672, administrative adjustment of claims. That's all we're doing is asking for the adjustment. Does that sound like an adjudication as it relates to the adjustment? The mentality of being just? The head of each federal agency or his designee, in accordance with regulations prescribed by the Attorney General, may consider, ascertain, adjust, determine, compromise, and settle any claim for money damages. So the money damages is what damaged you. The thought of using money when you didn't need to because you're a creditor unto the nations. Therefore, you're supposed to be using credit against the United States for injury or loss of property or personal injury or death caused by the negligent or wrongful act or omission of an employee of the agency while acting within the scope of his office or employment, under circumstances where the United States, if a private person, would be liable to the claimant in accordance with the law of the place where the act or omission occur. If a private person. So the corporation can't be found guilty unless first you can find a private person guilty. And in that, then you can make an adjustment of a claim as to 1 million versus 100 million by then posing it in their corporate capacity for the damage. Provided that any award, compromise, or settlement in excess of 25,000 shall be effected only with the prior approval of the Attorney General or his designee. Notwithstanding the proviso contained in the preceding sentence, any award, compromise, or settlement may be effected without prior written approval of the Attorney General or his or her designee, to the extent that the Attorney General delegates to the head of the agency the authority to make such award, compromise, or settlement. So he has to be able to delegate it. He must have done that already. Such delegations may not exceed the authority delegated by the Attorney General to the United States attorneys to settle claims for money damages against the United States. So he can't supersede at the state level any United States attorney. Each federal agency may use arbitration or other alternative means of dispute resolution. Equity. An alternative means of dispute resolution outside of the administrative courts of admiralty maritime laws or jurisdictions. Under the provision of subchapter 4 of chapter 5 of Title 5, to settle any tort claim against the United States. Again, I'm not making a tort claim. I'm making a correction of the records that would amount if a tort claim would come in certain levies. Again, I'm not even going to mention those. I'm going to let the record settle as best as I can without trying to be manipulative or anything. To the extent of the agency's authority to award, compromise, or settle such claim without the prior written approval of the Attorney General or his or her designee. So it's giving them the ability to be the negotiator in the negotiations. Negotiable instruments. Everything leads back to your ability to negotiate with these people at their level. Subject to the provisions of this title relating to civil actions on tort claims against the United States. This is again where if you have a tort claim, you claim it on the private side first in their private person, then you can make a civil action against the corporate entity against the United States. They can award the larger awards. Any such award, compromise, settlement, or determination shall be final and conclusive on all officers of the government, except when procured by means of fraud.
That's every bit of it.
Well, it's not, and you can't, again, equity says that you can't say it's fraud, but you can say that it is an error, and to move further without recognizing that error, without cognizing that error or any part of it, would be to, what did it say earlier, frustrate it, and therefore escalate, and therefore cause contempt and dissent. See, those are all relative terms, and it's important to learn how to use that language. Pointed out in all those different jurisdictions how those terms are synonymous. Are you actually dedicated to this process, or do you have some addiction or addiction to malfeasance, negligence, stupidity, idiocy, ignorance, willful neglect, wanton contempt? This is why I say people like me because I tell them the truth. The people that don't like me, they don't like me because I tell them the truth. I use simple terms. I repeat them synonymously throughout the different, so they really get the concept. Yeah, I think you're a bitch ass slave.
Yeah.
And I don't mean to be rude about it. I mean to be coarse. The acceptance
I
by
think.
claim of
Oh,
any,
go ahead.
yeah,
We'll talk
real
later.
quick. I just want to finish this up. The acceptance by the claimant of any such award, compromise, or settlement shall be final and conclusive on the claimant, and shall constitute a complete release of any claim against the United States and against the employee of the government whose act or omission gave rise to the claim by reason of the same subject matter. So again, it's a full acquittance and discharge under that 50 USC 4305. You're bringing the equity by putting it in the interest of the United States. Hey, we want you to help settle it so none of your employees of the government who have been, acting in omission of this because they didn't have the knowledge, forgive them, for they knew not what they did. So now we just, as part of the remedy, enforce an educational opportunity to say, hey, here's a way to better yourself by learning the true aspect of what you're supposed to be doing here. I think that's very reasonable.
Yes, sir.
I want to take a minute real quick to remind everybody, please hit that like, share, and subscribe button. As I once again remind you, I appreciate your support. And of course, there's PayPal links below for anybody who wants to share some love. And I can certainly drop the StreamYard link if I need to, but I think it's there already. As far as I can tell, let me know if it's not. I'll be glad to drop it again. And then let's see, I think I think I'll leave the next part for tomorrow night. Because like I said last night, I think I'm just going to keep them short in a nice series of videos again, because otherwise people lose attention, and it's easier to review them in the shorter sessions like this. So if you got anything else there, Russ, please let us know. And we'll say yo to yo to folks.
Yeah, no, I ain't really got nothing. I figured I'd come out and hang out with you. Missed about most of it the last one you did, except about the last 25, 30 minutes of it. I still got to go back and review the first part of that and get my notes out of that as well. But I would encourage anybody that is listening to anything that you're talking here to put some time into it, dive into it, people. Read a little bit. Without reading, I don't think they're going to get any comprehension.
Yep.
Possibly not. But my struggle is I can comprehend what I'm reading, but I already know it in my heart and soul already is what I think helps me with that comprehension. Because as everything's been a lie, so I'd like to see a lot less hate and a whole lot more love. It was kind of disheartening on that Saturday morning that night that they all got on me that way, and then I sit here and I look and I'm like, holy shit! That's still continuing.
Yeah, and see, that's why I say you got to realize that in this metaverse, nobody can really hurt you guys.
No.
So we got to realize everything here is fiction. Like I've said many times, comments etymologically, whether written or spoken, are inventions, fabrications, and fictions. And what that means is they're merely just the thoughts of another man's mind. They may even profess what comes from his heart, but generally they don't. They express what comes from his emotions. And so we have to realize that when people get into this ad hominem stuff and all that and try to disposition us, we've got to realize that first and foremost. And that's why I say the name is inherently important, but we got to remember where it's positioned first. Hallowed be thy name.
Right.
So let's start there.
Yeah. Maybe I just need to loosen up, Keith. Maybe I need to have a little excitement or something. Maybe I ought to get out there and just ride some asses.
Well, I'm hoping like I did with the birth certificate A to Z. I should have, and I might even do it yet, a longer series of videos on that aspect as well. But from A to Z, my process of trying to correct these records and everything, um, it's merely a simple process, like I said, of realizing your power yourself by just learning the knowledge of how it works. Once you realize how to step out of her, like you said earlier, step out of her and know that that person is the feminine. It's the person that has to be subject to something in fiction. That's that's an effeminate characteristic. It's a omega even, let alone just a beta, but an omega position even, as we think about it as relates to the spiritual, the manual, and the personal. The personal is just merely an extension of the man, whereas the spiritual is the forefront of the man that's supposed to guide that man in his personal dealings. And we've all been misconstrued as the person first and foremost. We have to be able to flip that table and act spiritually and guide the manual so the person behaves correctly, behaves correctly. The property is held in person. So if he's going to hold it, then he's got to maintain it properly.
Yes.
Anyway, with that, then I again appreciate your support tonight, Russ. In the meantime, everybody remember, I love you. I don't give a rat's ass whether you love me back or not. So may God bless you. Have a good night, and we'll see you again next time.
Much love, everybody. I'll see you tomorrow, Keith.
Bet.